Well, hello everyone. We are back again with our wonderful friend, Attorney Arthur Crooks, and we are on the second part of our four-part series, which may end up being longer, but for right now we've got 4 parts for you. And this part is going to be on durable power of attorney. Arthur is going to talk about a number of different things, so I'm going to let him get to it. And thank you for coming.
Again, thank you, Barbara, and just want to follow up that, as Barbara indicated, we've recently talked about certain advanced care directives in the health field, and those were the healthcare proxy, living will, and HIPAA document. When we talk about doing basic estate planning, the analogy I use is that of a house, and we have to put a foundation in. The health documents that we had recently talked about constitute 3 of those, and this is the 4th document to put the foundation fully in place. And this document is going to deal with your finances. In other words, if a situation arose where you cannot act in your own behalf due to incapacity, who is going to do the banking, deal with the insurance company, go to the post office, do everything in the financial realm as opposed to things in the healthcare realm? And again, I'm going to repeat a little bit of what I spoke about in the last session, in that you want to do this so you can determine what's going to happen as best you can in your future. You want to be able to name the person that you trust to take care of, quite frankly, your money and your assets. As George Carlin would say, your stuff, okay? That's very important. And if a situation arises where you become incapacitated and you don't have a document of this nature in place and you don't have trusts or anything, you may be going to the probate court and getting not a guardianship, but under the new law you have to get a conservatorship. And as I've explained before, and as I give my different seminars and presentations, I'm telling people now that not only are these documents suggested, required, mandatory, and as Barbara said, there's no excuse, because if you wind up going to court, you may get someone appointed that you don't particularly care for, and it's an extremely involved and expensive undertaking. So you want to be able to name in your own document who you want to take care of your finances during a period of incapacity, or the incapacity may be ongoing. And we're going to talk about that in this context.
We also talked about last time that it's important to pick a person who knows you well and for them to know you well. And the reason that I bring that up in this circumstances is lately we have had a few instances of people who have chosen someone that happened to be a friend. And the friend was very much in defense of the patient or the person, which is great. But now it's come to this person, let's just say, is in the hospital with a very difficult choice of having to go to rehab before they can go back home, if they can go back home. Well, the power of attorney got put into play at Cape Cod Hospital, and in that person's words, well, I'm not going to be the bad guy. I don't want to be the meanie and have to tell him that he can't go home right now and maybe never. Well, the kind of person that you choose needs to be able to do what is on your best behalf financially. And if that includes working with the hospital to get your affairs in order so you can go to rehab and then hopefully go home or have someone come live with you, then that's what that means. So you need to know that it isn't necessarily just picking up the mail and coming to visit you at Cape Cod Hospital.
That's correct. And Barbara brings up a very good point that quite frequently there's going to be an interplay between your health care documents and the person you've chosen to do your finances. For instance, there's an overlap there. You're in the hospital. Should you go to rehab? Should you be going home with a certain care in place? Is that appropriate? You may go to rehab and wind up having to stay in a long-term care facility. So you have an interplay here. And of course, if that were to happen, going to a long-term care facility, then we're talking about some major financial consequences, and then we get into a whole other area, which is mass health, Medicaid, nursing home finance planning, which we're also going to talk about. So Barbara's absolutely correct. You've got to be very careful who you pick, because at the time you choose someone and a backup, you may have no idea what's going to be happening down the line. So it's very important, and I'm going to go over some factors which you should go over. Now, in our last session, I made reference to a pamphlet, toolkit, which I'm in the process of sending to the press, and this is on advanced care planning. It's primarily having to do with the healthcare issues, but I've incorporated power of attorney matters into it. And once we get this back from the press, these will be widely available. They'll be at the Council on Aging, both here and throughout the Cape and at other facilities. So I just wanted you to keep that in mind. And once again, I just want to bring up the fact that we are doing a series of presentations in May, which we do every year. They're called the Forum. They'll be given in May, both in West Dennis at the Graded School, co-sponsored by the West Dennis Library. We're also going to do them in Provincetown to hit people down that end of the Cape in May also. If you go to my website, which is www.crookslaw.com, CROOKSLAW.com, it'll be in much greater detail. Also, as we indicated in our last session, this is a follow-up to an overall general presentation we did in December. That is available both here at the Harwich Council on disc, and I will have it on my website. You'll be able to see it there. And what we're doing now in these individual sessions is taking one item from each of the basics and reviewing them. And what we're going to talk about today is a durable power of attorney. Now, as Barbara knows, I am constantly pounding on people, especially since the new guardianship law went into effect. You must get these documents in place, both so that you can control your own future and avoid, usually it's putting your family through the difficulties of getting a guardianship, but yet 70 to 80% of people do not have these documents in place. I'd say every other week, the New York Times, the Boston Globe, you absolutely, AARP, put these documents together. I don't know why people aren't getting the message, but in Massachusetts, we now have the goad of our new guardianship law. In one of our sessions, we'll cover that, and you'll be very interested in what that entails if you don't have these documents in place.
You know, I think one of the reasons that I hear anyway is two things. One, people have them tied in with, quote, estate planning, and I wish there was a better word than estate planning, because they think of the mansions in Newport when you say estate planning. They don't think that their house that they've had and probably have paid off for many years is part of an estate. And you don't even have to have a big house to have an estate. As you said, George Carlin said, your stuff is your estate. And if you don't protect it and you don't have somebody in charge of it, if something happens to you, guess what? You end up with the court stepping in, and that is quite costly.
That's right. And to get back to the definition of an estate, the George Carlin, your stuff, if that's all I own, this paper clip, this is my estate. That's it. It's an estate with a small e, not a large e. And I'm going to talk about that a little as we go on. So what we're talking about, in order for you to appoint someone yourself without court interference, is something called a durable power of attorney. A power of attorney just means you're giving authority to someone else to act in your behalf. What durable means is that that authority is good through the duration of any incapacity you may have. Under Old English, the common law, when you gave someone a power of attorney, it used to cease if you became incapacitated. And that's not what we want here. So the law in the 1950s came up with this idea of a durable power of attorney. So whenever I see documents that other people may bring in, I want to see that word on there, durable, which means that if the person becomes incapacitated, that power of attorney is still going to be good. And quite frankly, that's what we want it for. we want for those periods of incapacity. When you name someone in the document to be your power of attorney and or the backup, you're creating what we call a fiduciary relationship. That means that person owes you a duty of loyalty within the context of handling your finances. And as Barbara mentioned, in the situation with someone at the hospital maybe going into a nursing home, you owe a duty of loyalty to that person. It's a fiduciary duty, and it can be kind of complicated in a situation like that where you have the overlapping health issues. And that's why, again, it's so important that you choose someone that's going to be able to do this for you effectively. And I'm going to talk about that a little later on as to how we do that. So,
and that you choose two different people.
That's
we
right.
get all the time people who say, well, why can't I just pick my son to be my healthcare proxy and my durable power of attorney?
Well, you can sometimes, but I tell people there are no rules, but let's look at the function they're going to play. You may have a son who's a brilliant surgeon, but doesn't want to have anything to do with your health care, but he may be a great stock picker. You may say, I have much more empathy with my daughter. I'm going to make her my healthcare proxy, even though she's a poet or an artist. My son might be a doctor, but I really don't want him having anything to do with my health. But boy, he's good on the stock market. He's done quite well by himself. I'd be comfortable with him. So there's no rules. Who are you comfortable with? If you're comfortable with your daughter for both these things, that's fine. But as we get into this discussion, you may want to take a closer look at possible conflicts of interest, past history. Is your daughter got financial problems of her own? Then you have to be kind of careful.
Or did you leave everything in your will to that same daughter? That could she have any unscrupulous reasons for wanting to bump you off?
We'll be talking about that later, and something I'm just going to throw in parenthetically now. Since the December talk, there's been one major change in the law, or a not change. That is, the federal estate tax, which was supposed to be extended this year, was not by the U.S. Congress. Some people call it congressional malpractice. Now, when you're talking $3.5 million estate value, we're going, well, that's not going to affect me. But there's a lot of other little things hidden in there that no one knows about. And this is where you may have possible conflicts with children and their inheritance. And I'm telling you, we used to joke about this, but the last week of December 2010 is probably a week you wouldn't want health care decisions being made for you by someone that maybe has a financial interest in your estate. So I'm getting a little ahead of myself. So when I do these presentations in the forums and you go to my website, quite frequently people will already have a power of attorney and they'll want me to look at it. So here's what happens. You bring the power of attorney to my office. The first thing I want to look at is, does it say a durable power of attorney? And hopefully it will. Or there's language in the power of attorney that says this is a durable power of attorney and is good through any period of incapacity. The first thing I'm going to look at, I'm going to flip to the end of it, I'm going to look at the date. I want to see when this was done. This is very important and had been very important in Massachusetts, and I think still is. In Massachusetts, the power of attorney does not have to be accepted. It's not mandatory. So if you bring it to a banker or an insurance agent or a stockbroker, he doesn't necessarily have to accept it. That's a judgment call on his part. A lot of other states, if it appears valid on its face, it has to be accepted. The trade-off is, in the other state, the person that accepts it is not going to be liable if he gives the money away and maybe he shouldn't have, whereas in Massachusetts, that third party, and that's what we call the banker or the insurance agent, maybe. So we look at the date. Why? Because for years in Massachusetts, this was the most common reason that was given for turning down a power of attorney. And several years ago, Fleet Bank, if your power of attorney was over 6 months old, would turn it down. which was kind of silly. You'd be doing these twice a year. The standard I have used up until last year is 5-6 years. You ought to take a look at it. You might want to renew it. You let it go too long, and the person that did it may no longer lack the capacity to execute the document. Now, last summer, as part of the new guardianship law, they repealed the whole power of attorney law in Massachusetts. Not too many people know that. So that was totally repealed. They brought it back in again. It's a part of the guardianship law, but they made some changes to it. And one of the changes they made was that a third party can no longer turn down a power of attorney based on it being too old, which is great. However, they could still turn it down for any other reason or no reason at all. So I'm indicating to you, and a lot of the books in this field have had to be rewritten, and this is the Bible that we use, and the writer agrees with me, you still should try and keep these things up to date. Because if they look at them and they're real old, they'll just tell you, well, I don't feel comfortable with this. They're not going to tell you they're turning it down because it's too old, because they can't. And they'd be subject to lawsuit if they did. So they're not going to tell you that. The writer of this book suggests doing them every 2 years. I still think that's, every 2 years seems like a lot. There's no right answer here. So that's the first thing I'm going to look at. It's still the first thing I'm going to look at. If you have a power of attorney that's 15 years old, you may want to take a good hard look at that, because if it gets turned down when you're trying to use it, and you're using it because whoever wrote it and named you is now incapacitated, you're not going to have the opportunity to update it because that person no longer has the capacity to do it. The second and third thing I would always look at, which I don't as much as I used to, is whether it has a gifting clause and a self-dealing clause. And I'm going to talk about that a little later as to just what I mean by those terms. Now, you've probably all seen the power of attorney that is one paragraph long. And it says, I let the person I appoint could do anything I could do if I were capable of doing it. Not a good idea. Those are not going to work. They're probably, in all likelihood, just going to be turned down out of hand. You've got to be specific. The power of attorney that I use is about 9 or 10 pages long. And we try and hit, tax powers, going to the post office, the business, anything to do with your real estate. We want to be as specific as we can because, and I did have this occur a few weeks ago, someone came in and it was a an insurance question, Medicare, having to do with the nursing home. And the old power of attorney they had didn't mention it, and the insurance company wouldn't deal with them. So I got mine out. It's around here someplace. I went through it and I said, there we go, paragraph 8, ability to deal with the insurance company. So that's very important that you be specific as possible. I've also seen these things 100 pages long. We don't want that either. So you just want something specific. Now, we generally just call all this stuff estate planning, and let's do it with a small e. But it just means that you're trying to get some control over issues in your own life. Remember, in your own life. When we start talking about wills and everything, your worries are over as far as your health care problems and your financial problems. So these things actually come before what we generally think of as estate planning, which is the will and the trust. Now, lots of people have living trusts, and they're told that the living trust, they've been to the seminar and they've heard the presentation, they've got the living trust, and that this is a cure-all. No, it's not. Living trusts do not do all the things that powers of attorney can do. Living trusts are just containers that you put assets into. They don't make decisions. You still need a power of attorney, even if you have a living trust. And I want that to be made clear. These are two completely different documents. And in some future presentations, we're going to talk about times when living trusts can cause a lot of problems. And they may not be appropriate for you. Now, once again, and I pound away at this, please get this document in place so that if something were to happen to you and you're incapacitated, you don't necessarily have to have your family going in at great expense and maybe even fighting about who's going to become the conservator. It's a whole new concept now. It's the conservator of your money and the guardian of your health. We now have two whole different concepts we're dealing with here. Now, one of the things I didn't mention in the last presentation, but I'm going to mention it now. Sometimes you have to go to court even if you have these documents in place. And if it's a healthcare proxy and you have to get a guardianship, the guardianship does not automatically overrule the healthcare proxy. So you can get into all sorts of problems. Under the new law, if you get a conservatorship for the protected person, we have all new terms we have to use, that does overrule a power of attorney that's out there. But what if the person doesn't know about it, or what if he's running around using the power of attorney? There can be all sorts of problems in that regard. Now, what are the requirements? What capacity do you have to do a power of attorney? You have to be competent. And as we mentioned in the last session, all people, all adults over 18 in Massachusetts are assumed to be competent until shown otherwise. Now, the capacity to do a power of attorney is not extraordinarily high. It's a little higher than the capacity required for a will, which is fairly low, which is, do you realize you have stuff? The George Carlin thing. And do you have family members who would be the natural bounty of receiving that stuff? That's about it for a will. We go a little higher for a power of attorney because you're going to give the power to someone to do stuff with your stuff. So we want you to realize what you're doing and what this entails. So again, once you do this, once you're decided you're going to create a power of attorney, which everyone should do, this is not situations where we're talking about someone that may be in a nursing home. You can be in accidents that can incapacitate you, maybe permanently. There's other medical issues that can incapacitate you permanently. Now, one of the biggest differences between the power of attorney, where you're going to name someone to do your finances, as opposed to the healthcare proxy, is when do they become effective? As we pointed out in our last session, the healthcare proxy is controlled by the doctor. If the doctor is unable to communicate with you or feels that you are incapable of communicating due to perhaps a dementia you have, he will activate the healthcare proxy, and then the healthcare proxy will step in and make your decisions. The power of attorney is different. The power of attorney that I do is something that comes into effect immediately, as opposed to being conditional. And we have legal terms for this, shifting and springing powers. But the power of attorney that I do, once it's signed and you've named Johnny or Susie as your power of attorney or your spouse, that is effective as soon as you sign it. Some people want to have conditions in there saying, no, I don't want it effective until Dr. Jones says I'm no longer have capacity. The reason we don't like doing that is, number one, where you have a third power who may not be a third party, who may not be too happy using this, we don't want to give them another excuse to turn it down. Or what's this Dr. Jones? Well, where's your letter from Dr. Jones? Or I'm not too comfortable with this. And if this is something we're trying to do in an emergency basis, Dr. Jones, excuse Dr. Friends, etc., he may be a little difficult to get in touch with. He may be on vacation. It may be Wednesday afternoon. So it's something that I don't do in my powers of attorney. So that person you name, the analogy is it's the live hand grenade. You're giving it to them. And the other thing I bring up, if you're the person that doesn't know someone, you're an aunt, you've never been married, and the only nephew you have is Johnny, and Johnny just got out of the House of Correction this morning after serving 6 months, are you going to give him your purse, so to speak? We might want to think about that. Now, what you can do, if you have someone that you really want to name, you're not totally thrilled about them, you can leave your document, your power of attorney, in escrow with someone, usually the attorney, and your instruction to the attorney is in writing. Do not release my power of attorney to my nephew Johnny until you get the letter from Dr. Jones that I'm lacking capacity to do so. That way it won't appear in the document itself and shouldn't cause a problem.
But the lacking capacity is the important piece. It's not like as soon as, even though it's effective, it's not like it's going into place the day you sign it.
What this is, pick your term, gentleman's agreement, understanding amongst family members. Dad, we're not going to use this. We know where it is in the house. It's in that big box. We're not going to use this until, in our judgment, we have to, okay? And between spouses, that's between spouses. If you have someone in a nursing home and it's very apparent that their capacity is totally gone as far as making financial decisions. But this is a trust thing.
And can you have a backup person for this? So
absolutely.
If my husband and I had each other, and God forbid we were in a car accident and both of us hurt or had something happen, you would have another
absolutely.
A backup person.
I don't do these documents unless there's a backup person. And I'm going to get into how we do that and who you might want to pick and just the mechanics of that. So the shifting and springing, is it conditional or not conditional? The way I do them, there's no condition on them. It's a matter of trust. So again, be very careful about who you choose. Again, Bernie Crooks, who's a leading elder law attorney in this field in New York, he spells it with a K, even though I tell him we're related. He wrote a big article for the New York Times last year called "The Durable Power of Attorney, a License to Steal, but Still Better Than Anything Else Out There." So you have to have a certain element of trust. If you don't, then go get a conservatorship. You can still do them voluntarily. I've only seen a handful of them done. I really, really don't think you want to do that. So even though there are some drawbacks here, you should still have the power of attorney and name the person you trust. Again, just the mechanics of it. I have them witnessed. I have them notarized. We do them in triplicate. Most people will leave original with us. Then the question comes, okay, I now have 2 originals of my power of attorney. What do I do with them? Well, it's your decision. Do you want to give an original to Johnny, who just got out of the House of Correction? That's your call. I'd probably be kind of careful with that because Johnny could be out that afternoon accessing your bank accounts. One of the things I tell people, and this applies to your health care documents also, do not put these in a safe deposit box because it is a guarantee that you always need these documents on the Friday afternoon of a holiday weekend, without fail.
So and you don't know where the key is.
Yeah, well, you can't. You got 4 days before the bank opens again. So everyone has that big box at home with the important papers in it. That's probably where you should leave it. And I've already talked about if you're uncomfortable, you might want to think about doing an escrow. Now, let's get back to who am I going to pick? In a spousal situation, as long as both spouses are competent, 99 times out of 100, they're going to name each other. Except we have things called second marriages or third and fourth marriages. Sometimes, that they may not be naming each other. They may choose an adult child from their first marriage. So again, there's no rules. You have to pick that person that you trust, someone who's trustworthy. And certainly, again, to go back to something we talked about before, don't stick someone's name in there and don't even tell them about it. And all of a sudden they find out when you're in the nursing home or something that they've been named to handle your finances. So you want to talk to this person and say, look, I'm going to name you, be it you're a child. You may have 9 children. I wouldn't name all of them, but you want to pick the one you're going to name. Do they have any expertise in this field? You don't want to name someone that can't even add 1 and 1, or has no expertise whatsoever. That's why I gave the analogy earlier of, you may have a daughter that is great with your health issues, but wouldn't be good for your financial issues. Here's the sticky one: conflicts of interest, and this is tough. Barbara's already brought it up. You may have someone that, by just making a couple of decisions that otherwise seem innocent and logical, that's going to benefit them more than it's going to benefit you. And you have to look at that. And this usually comes in with children who may have some financial problems. And that's, again, my tape down the middle of the desk. I'm telling you what the legal issues are. I don't know too much about your family dynamic. And that's something you've got to do, and you've got to be very careful about that. Multiple children in a blended marriage. We have kids on both sides, and I'm going to talk about whether we can appoint powers of attorney. I don't particularly like that, but there are instances where you might do it. So again, you've got to be very, very careful about who you name. Now, as I pointed out in our first session on the healthcare documents, the law on the healthcare proxy is very strict. You name one person and one backup. We don't have these rules in the power of attorney area. So yes, you can name multiple people to be your power of attorney. I don't like that. Why? Because you're guaranteeing fights. People aren't going to get along. In Massachusetts, when you have multiple fiduciaries, they're supposed to all agree. It's supposed to be a unanimous decision, unless you put in there that you would allow a majority vote. And then we're getting much too complex. Let's say you name each other, your husband and wife, you name each other, and you got 8 kids. We want to name all 8 of them as the backup. I'm going, well, I don't know if you really want to go there. How about naming them 1, 2, 3, 4, 5, 6, 7, 8 in order? Yeah, I guess you could do that. I very rarely see it done. Now, I want you ideally to name just one person. But let's look at this example. Let's say we have a couple, both in their early 90s, been married for well over 60 years. For them to name one another, and then something happens to the other one, you're now asking a person in their 90s to start making these very important decisions, and they're probably emotionally overwhelmed by the whole situation. Then I can see naming perhaps an adult child as a co-power of attorney in the first instance. I name my spouse Mary and my daughter Joan to act either individually or together in my best interest. That way, when it happens, mother's still there, but the heavy lifting can be done by the daughter. And that's one of the few exceptions where I will entertain naming 2 people as opposed to just the one. You don't want to build a fight right into the document or disagreements. In the olden days, people used to name banks and stuff like that. People don't do that anymore. You're going to name an individual that you've gone over all these factors. They're trustworthy. They have the expertise. They're willing to do it, et cetera, et cetera. Another thing that comes up all the time, and it usually comes up when the power of attorney is being used, and I'll get a call. It's usually the adult child. I'm doing all this stuff. Can I get paid for doing this? Well, that's something you can include right in your power of attorney. If you contemplate that if you're naming a child and maybe you have a very complicated financial life, maybe you do want to put something in there about paying them. Maybe you even want to mention a rate. Without putting anything in, the law in Massachusetts is that a fiduciary is entitled to a reasonable fee. Well, what about when the other kids find out about this? What's reasonable? the gray area again. I don't know. So if that's something that's going to come up, you may want to include that. This is tied into the concept of self-dealing. Now, what self-dealing means is that the power of attorney, and let's use again the oldest child, is going to be giving stuff to himself or herself. Now, this may be consistent with what you want. It may be consistent with Medicaid planning or mass health planning. But under the common law, you can't do that. The person you've named as your fiduciary can't give things to themselves. So you may want to have a clause in there, and it's called self-dealing. I hereby authorize the person I've named to actually give things to themselves. This used to be quite important in the mass health field before that was changed drastically 3 years ago. And I think we're going to have a session on that someplace down the line. By the same token, hand in hand with that is gifting. You may have a pattern of gifting, the $13,000 a year every year, and I'm not even going to get into the tax consequences. If you want that to continue, or if you want to have a wider gifting power, and this usually has, again, to do with mass health and Medicaid planning, you better put that in there too. And those are the three things I would always look at: the date, the self-dealing clause, and the gifting. And again, that's very important that you have that in there. One of the things that we talk about when I do the power of attorney is that you're naming the people that you want to act for you financially, and you're going to name the backup. The other thing that's very, very important in the power of attorney is you have an opportunity in that document, and it's at the end of my documents, to name who you'd want to be your guardian and or your conservator if you ever had to go to court. And as much as I'm trying to get you to do these documents, and I assume you will all do them, sometimes, no matter if you have the documents, you may wind up going to court. An example, you may have something to do in the financial realm. When you go to the banker or the stockbroker, they won't accept your document. And remember that they're not forced to. You may have to go to court then to get a guardianship or a conservatorship. Or in a worst case scenario, the kids are already fighting about things and you have to go to court. Well, what you can do in that document, your power of attorney document, you can say, if it ever occurs that we have to go to court and name a guardian for me or a conservator, notice that's split now. I've had to amend my powers of attorney so that when we're talking about health care issues, it's a guardian, and if we're talking about financial issues, it's a conservator. I appoint the following to be my guardian and the backup. I appoint the following to be my conservator and the backup if needed. And we're in the court 99 times out of 100 will follow your wishes. They will not pick someone like me off a list. And we're hoping the people you named aren't the bad guys. These are the people we're hoping that these are the people that you want and trust. They're generally going to be the people you've already named in that document anyway. So that's...
And they don't necessarily have to be the same person for the husband and wife, correct?
No, there are no rules here. You can pick different people completely. Where issues do arise is quite frequently in second marriage situations. Also, I have a lot of people that come in to me that say have moved to the Cape, they have never been married, they have no family, and I'll say, well, how about neighbors? Do you have, are you a member of a church? And they'll get no, and then they'll just be staring at me. And I'll go, I know what's coming next. Well, here's someone I don't know. They've just walked in the door, but they don't know anyone. So every once in a while, I'll say, well, why don't we think about this? Why don't you come back and we'll talk about it? Because I'd rather, if it came to that, have someone named than having to go to the court and get a guardianship. And as I tell people, there's a chance the example I gave in the last presentation of being named to make a major healthcare decision within an hour, half hour or an hour of my appointment. This is why we're doing these documents, so that you will have a say in this and control over it. So that being said, if you do these documents, they're properly executed. Again, we have them witnessed, we have them notarized. I also have at the end of my power of attorney a statement by the person who is making out the power of attorney that they fully understand what they're doing, that in fact they're giving total power to someone that they're naming, and they understand this. And that's to show their competency. Then the next document we have is a similar thing to be signed by the person that's being named, saying, yes, I understand I've been named. I understand I have a fiduciary duty to the person who's named me, and that I'm going to do everything correctly and in their best interest, etc. And we have them sign that. Now, what we had mentioned before is, and we've also talked about the fact that we do these documents in triplicate. It's important that people know where they are. And this is a document that, when we talked about healthcare documents, I actually put these on little discs. These are documents that I'm not going to have reduced to discs. I think this goes beyond healthcare concerns. Mm. The example you brought up in the beginning, where there are overlapping healthcare issues, that is true, but I don't consider this to be a healthcare document, although there are documents that state that in the healthcare proxy, they do have, in a power of attorney, there may be things that involve healthcare decision-making. And as we pointed out in our last presentation, if there's nothing else, those documents, the healthcare provisions in a power of attorney may be utilized if there's nothing else there. And again, this is all in the context of the new guardianship law, which is evolving. Now, let me bring up something that I talked about in the last session, but it applies here also. Under the new guardianship law, if someone is going to go into a nursing home and is deemed not to be capable of doing this on their own, which would be a rehab situation, you may have something in the power of attorney that says, I hereby authorize my agent to admit me to a nursing home facility as defined in the new act. And I try and incorporate that into the healthcare proxy and to the power of attorney. But I don't know if it's going to work or not. And so you may find yourself in a situation, if someone is going into a nursing home facility and you want to place them in and want to use the power of attorney, it may not work. You may have to go get the guardianship, and then you'll appreciate the fact that you've named in there who you want to be your guardian or your conservator. There may be situations that arise where someone is abusing the authority they have. And then, obviously, you're going to want to go to court and perhaps get that person removed. And these situations occur more often than we'd like to think about.
Do facilities actually do that? Like if that happened in a nursing home and the facility started to notice money was disappearing or something that seemed unscrupulous or unethical, do they have the power or the right to go on behalf of that patient to protect the patient?
Well, I've never seen it happen, and as I mentioned earlier, and perhaps in the last session, that I'm on the Council on Aging, Vice Chairman in Dennis, and I've talked to the person in Dennis who will be coming head of the Friends of Dennis Seniors next year. And this is a field that he's terribly concerned about. Abuse of elders, both be it financial or otherwise. And more often than not, this is done by a family member, okay? And you may get elder services involved. Occasionally, I've seen referrals to elder services, but it's a very difficult area to get into. And the nursing homes generally don't particularly like getting into that. You may have other family members. I have found that elder services is probably going to be the most effective way to go. If it's really outrageous, if it is bordering on the criminal or not already criminal, and I have a matter like this right now where the grandson, unbeknownst to anyone, was using the authority that his mother had for grandmother, and mother had died.
Oh,
and the
boy.
grandson was still, he stole everything. Now, to bring that to the criminal side is very difficult because of criminal standards, beyond a reasonable doubt. Grandmother wanted me to have a gift of this and that. And the money is always gone anyway. Once the money is gone, you're never going to get it back. That's a foregone conclusion. So if another family member sees something is going on, and I'm involved in one of these right now, then you're going to wind up going to court and getting the guardianship. So once again, that brings us back to you've really got to be careful who you choose to do this and taking into account all those other factors. So what I want to emphasize again is when I get that phone call about I need a will or a trust, before you do that, you want to get your advance care directives, and this includes the power of attorney. You want to get these all in place. And if you have them all in place and they're drafted with an eye towards all these new things in the guardianship law, and in every possible situation wherein you may have need for it, chances are pretty good you're going to avoid having to go to the probate court. But if you do, and you have your documents in place, the court's going to look at those, and that will give guidance to the court in any event. So once again, this is not optional, no excuses. It's mandatory to get these documents, both so that you will be comfortable with your own situation, and if it ever reaches a point where you're incapacitated, it's not going to fall to your family to have to go over and get a guardianship, and it may be, it's going to be very involved and expensive, and it may lead to interfamily problems that could be avoided if you do these documents in advance. So any follow-up questions, Barbara?
No, I will say, though, that the first time in December that Arthur came to us to do this segment for us, the broader segment that we're now breaking down into pieces, was the largest DVD request that, at least as far as the Council on Aging programs have gone, that Joe Mason, our Channel 18 director, has received. So I can only imagine that this series will be as well. But I do want to remind you, we will have them available in addition to watching it on the station on DVD for lending. So if you started with us and you're trying to write fast and furious, you really don't need to. You can get the DVD, borrow it from us, and or get your own copy and start writing from that, so you can listen to the document at your leisure and not feel like you're having to be rushed.
And also to follow up on that, as I get the DVDs, I will be putting them on my website, and you can sit there and watch them as often as you want, and they should all be available, including the one I gave in December, which, as Barbara mentioned, was just a broad general overview. And what we're going to try and do in the next couple of sessions is actually get into the more classical things that people think of as estate planning, and that's wills. And the one thing I want to say about wills is everybody in Massachusetts has a will. If you haven't written your own, the Commonwealth has written it for you. And you may not like the provisions that the Commonwealth has in your will. And if you have any stuff, be it a paperclip or more, you should be concerned about the will. And then in conjunction with that, we'll be talking about trusts. At some point, I've talked to Barbara about this, when people come to me and want to talk about estate planning, what we talk about is Roman numeral 1, well, what is your stuff? Who's going to get it? Where is it going to go? Number 2, how much stuff do you have? If in Massachusetts you have over $1 million and a nice house and a stock portfolio may get you there sooner than you think, You may have an estate tax issue in Massachusetts. Remember, the federal estate tax is a huge question mark because no one knows what's going on there. And third, we've done all this wonderful planning, and now my spouse or a loved one is in long-term care at $8,000, $9,000 a month. What does this do to all the planning we've done? So we probably are going to spend some time talking about what that entails and what planning can you do as a married person, as a single person. Also in this overlay, there's different ways that non-traditional families are affected by this because of the law in Massachusetts. And then we can get into the guardianships, and I think that's important because you've got to understand what's involved in the whole new guardianship realm. And let me mention something else. The new guardianship law is part of a whole package of new law and reform that's coming into effect in July of 2011. You've always heard that, why are you doing this? I want to avoid probate. Well, probate has a lot of problems, but the new law is designed to correct a lot of those problems and make probate a lot simpler. The guardianship portion of it was taken out and kind of put into place 2 years earlier, and that's accounting for a lot of the problems we have. And then at some place along the line, I'll probably get into a little bit about veterans' benefits in a very narrow sense. There's certain areas, Social Security, Medicare, veterans, which are so vast, there's no way of covering them completely. But there are a couple of benefits that I think are very important in our overall context of the basics of estate planning. And as Barbara said, you don't need the mansion on Nantucket or Newport to be worried about estate planning. Because if you've got anything and you want it to go to someone else, you've got to put these things in place yourself, or the Commonwealth will do it for you, maybe not to your liking. So once again, I want to thank Barbara and Harwich Council on Aging for having me here. And I look forward to doing some more of these presentations to get into the day-to-day stuff that we talked about generally in December.
Well, thank you very much for being here. And we will have, when Arthur gets the advanced little packet of how to plan, once those are available, we will have them. And we will let you know on this station as well. Thank you again for tuning in.
Thank you.